Hello and welcome to The Big Picture. I'm Tina Jha. 8 years after giving voters the option to use Nota, that is none of the above option in the polls, the Supreme Court has now sought responses from the Centre and the Election Commission on whether it would be legally permissible to reject all candidates in the fray if Nota votes exceeded that of the candidate securing the highest number of votes. The top court was hearing a plea that seeks to direct the poll panel to nullify an election result and conduct a fresh poll if the maximum votes are for none of the above in a particular constituency. The petition says that the right to reject and elect a new candidate will give power to the people to express their discontent. And if voters are dissatisfied with the background or performance of the contesting candidate, they will opt for Nota to reject such candidate and then elect a new one. The contesting candidates rejected in the nullified elections shall not be allowed to participate in the fresh election. This, the petitioner believes, will help check the steadily rising percentage of candidates with criminal antecedents and also their chances of winning. Although, while hearing the plea on Monday, Chief Justice CJI Bobde said that in our electoral system, such a move could be counterproductive. Many seats in Parliament and assemblies could go vacant and constituencies could go unrepresented for a long time. So on the big picture today, we will discuss with experts the significance of Nota. Should it be given more teeth so as to ensure that political parties are more responsible when it comes to selecting candidates? And if it is to be strengthened, what should be the best way to go about it? For this, two special guests are joining me on the program. Let me introduce them to you. We are joined by Mr. O.P. Rawat, former Chief Election Commissioner, and Mr. Desh Ratan Nigam, his advocate, Supreme Court. Welcome, gentlemen, on this edition of The Big Picture. Mr. Rawat, let me begin the program with you today with your views on the plea in the Supreme Court that seeks to nullify an election result if Nota gets maximum number of votes.
This issue has been in discussion for quite some time. The problem is with the Rule 64 of conduct of election rules. Rule 64 says that the returning officer shall declare a candidate who secures the maximum number of votes as elected. Now, Nota is not a candidate. And therefore, even if Nota gets highest number of votes, cannot be declared elected or the election cannot be nullified. Even if 99.99% votes go to Nota, and if just one vote is secured by one candidate, that candidate will have to be declared elected according to this rule. So unless this rule is amended, there is no scope for having re-election because Nota has got maximum number of votes. Another thing is there are many other options. Not that fresh election is required if Nota gets maximum number of votes. What one can think of to begin with, if Nota has certain number of votes and there are 10 candidates who secure less number of votes than Nota, we can think of disqualifying all these candidates for a period of 6 years, that they cannot fight any election for 6 years, to give a message to the political parties that please field good candidates who are not rejected in this manner by the electing people. In fact, you can also have an option under the Conduct of Election Rules and RP Act 1951, where we can provide for that in case there are a number of parties which field candidate who fail to secure equal or more votes than Nota, then these parties can be asked to fund the fresh poll if fresh poll is required. Because, you know, public cannot be punished for the mistake or for the wrongdoing of some other stakeholders.
Yes.
All these options need to be weighed with pros and cons, and only then we should start, or we can make a small beginning. In fact, Maharashtra State Election Commission said that under plenary powers, they are trying to bring in this provision that if no candidate secures more vote than Nota, they will have fresh elections. But I don't think this was ever implemented. So there is a need for giving more teeth to Nota. But right now, it is only giving total secrecy to a voter's voting behavior, because we know that abuse of money in our elections is rampant and it is rising by the day. And therefore, every voter is very, very sort of scared that in case candidates are watching, a lot of money has been distributed. In case he doesn't go to vote, they may create problems. In case that polling station gives maximum number of votes to a candidate who has not distributed money, but less number of votes vote to that candidate who has distributed money, there may be a backlash.
I
So
think
Nota
that's where the
provides
argument is that, the purpose of bringing about Nota was to decriminalize politics and also to ensure that political parties, when they select their candidates, they are more responsible. Mr. Nigam, in a democracy, every vote is precious. Many a time what we see in constituencies that candidates win by a margin of one vote. That is the value of one vote in a democracy. But the same value it does not hold for those who choose to go with Nota. So do you agree that it is time to change that and add some value to Nota?
Tina ji, let us have these statistics before we come to this conclusion. In 2014, 1.11% of the total electorate was under Nota, the votes polled. And 2019, it decreased to 1.08. If we take these two elections, the Nota is decreasing. Now, about 1% of vote in the total polled votes does not mean the system is not functioning properly. It is functioning properly, and 1% of vote means it is not significant. And the system is working properly. However, this PIL is only about if the votes polled under Nota is more than the votes polled by the winning candidate. So that's very important. It is not about winning margin. And secondly, fresh elections to take place in that scenario, and subsequently candidates who had contested in the earlier elections, which has been nullified, should be barred. These are the three pleas which are there before the court. Now, I agree with Mr. Rawat that unless and until you change the law on the subject, it will be very difficult to do it. And I am for one person who believes in democratic values and principles. This law must come through the parliament and it has to be discussed threadbare. Although Supreme Court got it through a judgment in PUCL case in 2013, but that is not the way law should be made in this country. Because this is something which concerns people. This is something where people have to think about it, and it can only be done through their elected representatives and in a parliament and to be discussed. Now, if you take my personal opinion, I would agree only if there is more Nota votes than the total votes polled by the winning candidate. That is one proposition that one can, go for. It seems very sound also. It seems reasonable also. And barring those candidates for some time, as Mr. Rawat said, for example, for 6 years, that can also be explored. But this is a complex issue. It's not a very simple issue. Yes. Another option could be to think in terms of, proportion of votes, in terms of, say, these are the votes which have been, polled under various candidates and the Nota votes. What is their proportion? That proportion can also be looked into for deciding whether it has to be nullified or not to be nullified. So various options could be there. But let me tell you, our present system is working. It is near perfect system. But if you want to make it an absolutely perfect system, this PIL seems to be a very sound PIL. Only in the case if candidate who is won, his votes are less than the total votes under Nota.
Okay. Mr. Rawat, so if we talk about decriminalizing, which was one of the objectives when Nota was brought about in 2013, so when we say that Nota should be given more teeth, and especially when it garners more votes than any other candidate, do you think it will act as a pressure on the political parties as far as selecting clean candidates is concerned? By far, it has not had a very, very positive impact. People have understood a little bit of importance of Nota, and somewhere in state elections, we have seen that in some constituencies, Nota has been, one option that the people have exercised. But as far as political parties are concerned, because the value of Nota is zero, the selection of candidates is not as clean, as sound as the people would want it to be.
Actually, till now, the Nota option has served the purpose of voter secrecy. That voter goes to the polling station, doesn't want to vote to anyone, so that scale is not tilted, inviting backlash from the person who wants all the votes there, and he comes back after pressing Nota. So that purpose is being served by Nota, and therefore this number is not very high. Our previous speaker said that it is a 1%, 1.08%, because there is no provision that if you vote whole hog for Nota, there will be some consequence. And that's why this number will never rise. This will be hovering around 1, 2, 3% at the most. In case there is a change by Parliament in the law, as he said, there may be motivation among the people to do that. That they press Nota more number of times than any of the candidates, including the winning candidate. And then the situation will arise that you have to decide. Now, for that decision also, what I said earlier, that you can have a number of options and Parliament can discuss which option to begin with to test the waters, whether we are ready for that kind of rejection or still not ready.
Does the Election Commission have no such powers to implement it? Does it have to go through Parliament?
Yes, because rule-making power is with the Parliament and Government of India. Rule-making power is not with the Election Commission.
So under the existing provisions, this can't be exercised?
Under this provision, it cannot be done.
Okay, okay. Mr. Nigam, coming back to the point that has been made in the plea by the petitioner as well, and that is to check the increasing percentage of candidates with criminal background, and that is one of the objectives cited in 2013 order of the Supreme Court as well, to ensure that political parties go on and choose their candidates responsibly so that they serve the people in the proper way as democracy needs it to be. Now, the plea also suggests that by far Nota has not had any worthwhile impact. Can a difference be made if Nota is strengthened?
Tina ji, one thing is very clear, that unless and until the law is brought on the subject or the Supreme Court intervenes through a judge-made law, it is only then it can be implemented. The objective was to have candidates with clean track record. However, if you look at, because of the judge-made law and the various laws that has come in existence, the candidates who have been convicted cannot contest elections. You remember the case of Shashikala. Now, she cannot contest for 6 years. Therefore, such kind of laws have already deterred political parties. They cannot field such kind of candidates who have already been convicted. However, if there is a case against a person, then he is not convicted, and tomorrow if he is not convicted and acquitted by the court, and then, if you try to prevent such a person from contesting election, then the questions of right to equality comes into the picture. And therefore, it becomes very difficult if somebody has a case, maybe a false case. In politics, a lot of false cases are also, foisted against the opponents. So that becomes a very, gray area. So how do you select a clean candidate? I think it should be left to political parties and their wisdom, because winnability is the most important factor in the elections. They require a candidate who can win. And especially in view of the laws, a convicted candidate cannot contest elections. I think it is holding grounds. But to strengthen democracy, as I said, this PIL is very important, especially only in the case of one scenario, that Nota exceeds the winning candidate's votes.
Yes.
Therefore, that option can be explored, and accordingly, a law can be made, either a judge-made law or made by the Parliament. And that is the only democratic principle that we have. Democracy has its flaws. It's not perfect. Let us be very clear. We don't choose a perfect man or a woman. We try to choose the best candidate. The best is not in terms of its absoluteness, the best among the choices that you have. Now, if good people are not coming out to contest election, people cannot be forced. It is only the people who are there. And therefore, the surrounding laws that exist today have forced the political parties to come out with clean candidates. Now, tomorrow, if a candidate who wins is finally convicted by the court, he has to lose his seat, whether it is in the assembly or in the parliament. However, if one wants to get into such kind of a system, a trial can be done at the lowest level of the democracy, that is the grassroots level of democracy, say in panchayat elections. It can be tried. Trial and error method is the best. It cannot be done straight away in the assemblies or in the parliament. Otherwise, that question which the Supreme Court raised, it can be counterproductive and a lot of seats can go vacant and it can affect the formation of the government. So let us start at the lowest level, see what kind of reaction people have, what kind of challenges it throws. Once it passes the test at the lowest level, it can be slowly implemented. Again, I am saying the Nota percentages are very low. However, Mr. Rawat says that once you give a teeth to such kind of a legislation, then probably Nota might increase. That is a speculation. It can be true or it cannot be true. So it has to be given a trial and error at the lowest level. If the Nota percentage increases, then we can be sure that, okay, that is speculation, that the hypothesis that we are trying to frame becomes a theory, a proven theory. So I think we should not be jumping the gun. The existing system is doing very good, but as an experiment, it can be done at a grassroots level.
Mr. Rawat, there is an argument to the assertion that this move could be counterproductive because there are those who contend that the seats remain vacant even now. For example, if someone passes away or someone leaves the seat, till the next by-polls are announced, the seat does remain vacant. So why not in case of Nota?
This argument that there will be many seats vacant, this is also speculation and cannot be said because our electorate has come of age. They are mature enough to give a different judgment in the same polling booth. Two electronic voting machines there, one gives majority to a regional party and the other gives majority of seats to national level party. This happened in 2019 election in quite a few seats. So we must have full faith in our electors. And I can tell you one example. In 1999 municipal elections in Madhya Pradesh, it is the Jabalpur district, where people came together, decided that if both the parties, because there were only two major parties there, BJP and the Congress, if both the parties feel candidates who are not suitable to perform these duties, we will put up somebody from third gender and ensure that he wins or she wins. And four of them won. One of the mayor won in Sihora. So people were really fed up of this kind of incapable candidates by both the parties, and they gave a message to the political parties. However, that message was not heard. There was not due publicity to it. And therefore, we are again talking about Nota and all these options. In my opinion, if we can start, like Mr. Nigam said, if we can start somewhere, like local elections, panchayat or municipal elections, we can start somewhere and have number of options, not only having a fresh poll, because that may be very expensive, because you have to go through the whole process. And parties, candidates have also to go through the whole process. They have to spend a lot of money on campaigning again and again. So if we can have different options available and start with some option like penalizing those parties who are not listening to the people in some way, like penalizing the candidate for 6 years, like asking for the money for holding fresh poll from the party concerned, whose candidate secures lesser number of votes than Nota. These are the options to be explored. And while amending the law, you can discuss all these options, and whatever our people's representatives think that this is the fit for our democratic exercise, that can be adopted.
Okay, Mr. Nigam, penalizing the candidates, has been one suggestion, but another argument against this could be that the candidates then would go on to say that their right to contest elections is being curtailed. And of course, the candidates have a right to contest elections and they will say their rights are being curtailed. So that could be a challenge if we are to implement this and if we are to add more value to Nota. How can this be taken care of?
Yes, it's a complex issue because your constitution gives guarantee to right to equality. If somebody else is allowed to contest an election, then why can't another person contest an election?
Yes.
However, here the law needs to be changed and it has to be tested against the fundamental rights in the constitution. And once that is cleared by the Supreme Court, if at all it is challenged, then you can say that the people in the first instance where nota votes were more have already given a verdict against you. So people's will and mandates become supreme in a democracy. So our constitution also talks of the will of the people, whether it is at the local level, state level, or the national level. Once that will has been expressed by the people, I think it can take care of that fundamental right, because in the first instance, you were given a right to contest an election. That equality was already there. Once the people have given their verdict through nota, then you cannot claim the second step of right to equality, because that has already been taken care of by the people, the will of the people, where they have expressed their displeasure by voting nota. So I think it is an option which can be taken care of by, through legal and constitutional means. And then the argument that there is a right to equality and things can be taken care of.
Mr. Rawat, so complex issue this is. There is no doubt nota needs to be empowered, but how do we strike a balance between taking care of the fundamental rights of everyone, be it the candidates, be it the voters, and of course the political parties as well, and which is in the best interest of democracy? That of course is the most significant part.
But I think, as Mr. Nigam said, there are issues not concerning fundamental right here, because you were given the opportunity to get elected, you contested the election, and then people rejected you. Under the law, you have been disqualified. So there won't be any issue of fundamental right in this matter. We must look for some other reforms, because getting decriminalization of politics through nota and other things improved through nota, I think it's too circuitous. What we need to do, that abuse of money should be in the focus. We should have ceiling on party expenditure so that abuse of money is stopped. Then about criminalization. Supreme Court has already done a lot, that you will have to declare all your criminal antecedents. You will have to publish these things in the local media so that people know. And in fact, there are instances that all candidates' criminal records were put on the polling station also. That these are the candidates having this kind of criminal records you are going to choose from. So all those things have been done, and whatever more is required to be done by way of some electoral reforms can be ushered in, and nota can be left alone, not as an instrument to bring about those reforms. We can think of nota for some other thing instead of bringing in these reforms.
Okay, so with that, I'll have to call it a wrap on this edition of The Big Picture. Thank you to both my guests for joining me on the program and putting your perspective on the subject, sharing it with us and our viewers. Pleasure having you on the program. So that's it from us on this edition of The Big Picture. Thank you for your time.